Hello, everybody. Just still getting set up here. Welcome in. Hopefully, still getting set up. I'm hoping everyone is having a good day today. I mean, it's Tuesday. At least we made it past Monday, right? So there's that. At least we made it past Monday. Yay, yeah, that's good. We'll cheer for that. Hello. So I've had a little bit of difficulty, everyone, kind of setting the times for my lives. So if you feel like you've missed one, you haven't. I've just not been able to get on recently. The last few days have been a bit bumpy for me. So it's taken me a little while to be able to come in. Hello, Edith. Good morning to you too. But I'm hoping to be able to get back on track again now. I'm doing much better. So I wanted to go ahead and just jump on the TikTok this morning. I will be doing my YouTube lives as well. I'm going to be over there hopefully later, but we'll see exactly when. So I can catch up with everybody over there as well. Hello, SK. Good to see you. But I do have a document for us to kind of go through here. It just came out a few days ago. This is an order out of the District of Columbia. And this is one of the lawsuits that had been filed against the Trump administration for firing Miss Wilcox. She had been removed from her position. And the judge, I tell you what, this order is just like really, really good. Of course, it's already being appealed, but the decision itself, I thought, was quite excellent and something pretty solid for other jurisdictions to be able to hang their hats on. Good morning. So I thought, let's go ahead and go through it because it was just so well written to kind of get us jump back into the swing of things here, everybody. So hold on, let me grab my, grab my pen. Oh, it's been kind of crazy lately. To say the least. All over the place. It's been pretty crazy. Hello, Chris. Hello. So let me go ahead and put the sticky note up here. So this case, again, this is Wilcox versus Trump. So his administration here. And Kaplan. So Kaplan is the chair of the National Labor Relations Board. And so she, again, brought a lawsuit for, unfair termination because she was terminated out of her position well before her position was to be filled again. So she filed a lawsuit and the court came out and said, yep, you should not have pulled her. So how bad did the judge go off? I thought it was very well written to be used as excellent precedent in the future. So we're not going to see, stuff getting thrown around in this particular order. Although I have to say there are a couple of cases, everyone, where people are asking for sanctions in one situation. Another one's got this huge fight for discovery. And I've not seen this before, but there's a fight for discovery and the judge is like, you guys need to clarify what this whole case is about. So they've done motions for clarifications, and then the defendant, which is the government's like, we refuse to clarify. And the plaintiffs are like, but we don't know what you want. And it's ugly. There are a couple suits in here that are getting pretty ugly. But we'll just, keep on trucking here as we go through these cases. I think we're up to 115 cases now against the administration. So that's quite a bit. And so this is the opinion here. And this was done on March 6th. I am not at my normal time. I usually don't go this early in the morning. And I haven't over the last couple of weeks, but this is just the time that worked for me this morning to dive into it. So, here we go. Welcome everyone who's still getting the notifications as you come on in. Hello, June Marie, good to see you. Yeah, it's been a while since I've been on. I apologize for that. Time has just not been my friend recently, so it's been a bit rough. But I thought we could go ahead and go through this. Here's our number here. If you're looking to pull this case up, it is available online. Here's our case number at the very top. In the middle is the document number. So this is document number 35, which I'll be reading through chunks of today. It's a 36-page opinion, so I won't be reading every single page, but I'll take you through kind of the more important things, of course. This was filed on the 6th, so just a few days ago, in the District of Columbia. So the United States District Courts, we're in federal court here because, of course, we are suing the federal government. That's who our plaintiff, Ms. Wilcox, is suing Mr. Trump and Mr. Kaplan here. No, this was not a decision in favor. No, this was a decision against the government and pretty sternly worded, talking about separation of powers and that presidential power did not cover the termination of this position, of this woman from this position, and that it was wrong. And it's been written in such a way that I think it will really set some nice precedent for future cases that we'll have that are still going on. No problem, Fred. No problem. No, it's all right. Nope, everyone's just kind of getting back into the groove here. So let me go ahead and get started. I will just ask everyone to be polite. My moderators always are working so hard, and so they may not be here yet, and if they are, they can't stay for too long. So don't be too rude if possible. And I'll go ahead and get jumping right in here, everyone. So we've got Gwen Wilcox, who is the plaintiff against Mr. Trump and Mr. Kaplan in his official capacity as chairman of the National Labor Relations Board. So this is the NLRB. And I think out of all of the people to fire, if you're pulling someone off of a labor relations board, you're probably going to get called out on it. And that's what happened here. So, memorandum opinion. Scholars have long debated the degree to which the framers intended to consolidate executive power in the president. The unitary executive theory, the theory in its purest form, that under our tripartite constitutional framework, executive power lodges in a single individual, the president, who may thus exercise complete control over all executive branch subordinates without interference by Congress, has been lauded by some as the hallmark of an energetic, politically accountable government, while rebuked by others as anti-American, a myth, and invented history. So just right out the gates, the judge is not impressed here. Now, bumping down here, he's just citing different articles, law review articles. One's from Notre Dame here. Another one's from Columbia and Alabama. So that's what those citations are there. Both sides of this debate raise valid concerns, but this is no mere academic exercise. And then footnote 2 down here, again, is just citing two further references. The outcome of this debate has profound consequences on how we Americans are governed. On the one hand, democratic principles militate against a headless fourth branch. And we have footnote number 3 down here, which is quoting from a 1974 law review article. Made up of politically unaccountable independent government entities that might become agents of corrupt factions or private interest groups instead of the voting public. Additionally, at least theoretically, empowering a president with absolute control over how the executive branch operates, including the power to, quote, clean house of federal employees, would promote efficient implementation of presidential policies and campaign promises that are responsive to the national electorate. On the other hand, the advantages of impartial expert-driven decision-making and congressional checks on an executive authority favor some agency independence from political changes in presidential administrations, with the concomitant benefits of stabilities, reliability, and moderation in government actions. No matter where these pros and cons may lead, the crucial question here is, what does the United States Constitution allow? So that's a pretty big opening paragraph from the judge here. Let me go ahead and put up here, just for anyone who's joining that's new, that it is a holding against the government. So I'm just going to put in here, government was wrong. All right, we'll just make it easy peasy in that. Quite right, yes, and I will be over on the YouTube also. To start, the framers made clear that no one in our system of government was meant to be king, the president included, and not just in name only. Citing the U.S. Constitution, Article 1, Section 9, Clause 8, no title of nobility shall be granted by the United States. Indeed, the very structure of the Constitution was designed to ensure no one branch of government had absolute power, despite the perceived inefficiencies, inevitable delays, and seemingly anti-democratic consequences that may flow from the checks and balances. Foundational to our constitutional system of governance. The Constitution provides guideposts to govern inter-branch relations, but does not fully delineate the contours of the executive power or the degree to which the other two branches may place checks on the president's execution of laws. As pertinent here, the Constitution does not even once mention removal of executive branch officers. The only process to end federal service provided in the Constitution is impeachment, applicable to limited offices like judges and the president, after a burdensome political process. And then he's citing into Article 2, Section 4, and also into Article 3, Section 1. This constitutional silence on removal perplexes the first Congress, bedeviled a president shortly thereafter and a second president after the Civil War during Reconstruction, leading to condemnation of the former and impeachment proceedings against the latter, and has best jurists and scholars in our modern era. And then we have footnote number 4 here. Kaplan is the head of the board. So he's in charge of the board. That's why he was named. She was pulled off the board. In 1834, President Andrew Jackson fired 2 secretaries of the Treasury when each refused his order to remove U.S. funds from the Second National Bank, which Jackson viewed as having, quote, resisted his reelection in part with bank funds, end quote. And these removal actions triggered a congressional condemnation resolution for an abuse of power. So historically, some people may say, well, I'm tired of living through these new things. But actually, this has kind of already happened to some extent with Jackson. A lot of the things that Mr. Trump has done are very similar to Jackson's presidency. The resolution condemning, hold on here, everyone. Okay, the resolution condemning President Jackson was ultimately expunged in 1837, but not without significant debate and Jackson's reputational decline. Yet, in assessing separation of powers, the Constitution itself is not the only available guide. Historical practice and a body of case law are respectively instructive and binding. And then he's citing the Zavodowski versus Kerry case, where it's saying, in separation of power cases, this court has often put significant weight upon historical practice. Both make clear that textual Silence regarding removal does not confer absolute authority on the president to willy-nilly override a congressional judgment that expertise and insulation from direct presidential control take priority when a federal officer is tasked with carrying out certain adjudicative or administrative functions. As Justice Louis Brandeis eloquently opined, checks and balances are established in order that this should be a government of laws and not of men. Observing further that the separation of powers was not adopted to promote efficiency, but to preclude the exercise of arbitrary power. I think that's a really, really important piece here with that language, is that the whole reason why we have checks and balances isn't because we're trying to be efficient. It's because we're trying to not have too much power placed in one branch of the government. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among three departments, to save the people from an autocracy. So the whole goal was to keep the country from becoming an autocracy, all right? So I think that piece is one of the most important arguable pieces that the judge is citing here. And we're pulling this out of the Myers case. So when you have people saying, well, you don't want to get rid of fraud, or you don't want to make things more efficient, efficiency was not the goal of the Constitution. The prevention of an autocracy was the goal. A president who touts an image of himself as king or a dictator, and then we've got footnote 5 here, where we've got a White House ex February 19th of 2025 at 1:58 p.m. citing "Long live the king." And that's where he's putting in here where Trump is comparing himself to a king. And then next, he who saves his country does not violate any law. So that's also being cited. Some of the defendants as kings supporting amici also draw analogies of the British monarchy. Tennessee has described the tradition of the British king's prerogative power to remove executive officers at will, which carried into the United States. So in a democracy created to repudiate that very regime, that analogy has little purchase. So what the judge is saying here, everyone, is that all of these references to this king-like power that Mr. Trump is trying to make is actually showing the court that what he's trying to do is unconstitutional, because it's going against what was the intent of the Constitution by making these references. So other briefs have come in, amicus briefs have come in and said, well, you know, he can do whatever he wants. Well, according to how kings rule, and the judge is saying that's why it's not okay to do that here. Next, perhaps as his vision of effective leadership fundamentally misapprehends the role under Article 2 of the U.S. Constitution. In our constitutional order, the president is tasked to be a conscientious custodian of the law, albeit an energetic one, to take care of effectuating his enumerated duties, including the laws enacted by the Congress and is interpreted by the judiciary. Citing Article 2, Section 3 of the Constitution, he shall take care that the laws be faithfully executed. And this is what we refer to as the take care clause, in case you've heard that phrase being bandied about. Here at issue in this case is the president's insistence that he has authority to fire whomever he wants within the executive branch, overriding any congressionally mandated law in his way. Citing a letter from Sarah Harris as the acting Solicitor General to Senator Richard Durbin on restrictions. So the judge is actually looking at this letter saying, hey, we can fire whomever we want. And he's saying, well, that's not right. That's not how that's supposed to be. Here's the rest of the letter citation here. We've got another letter, February 12th, describing the Trump administration's view of the removal power. Luckily, the framers, anticipating such a power grab, vested in Article 3, not Article 2, the power to interpret the law, including resolving conflicts about congressional checks on presidential authority. The president's interpretation of the scope of his constitutional power, or more aptly, his aspiration, is flat wrong. Again, that's very bold language here of this judge who is not pleased with what has happened here. The president does not have the authority to terminate members of the National Labor Relations Board at will, and his attempt to fire plaintiff from her position on the board was a blatant violation of the law. Defendants concede that removal of plaintiff as a board member violates the terms of the applicable statute, so they even agreed that they violated the law here. And because the statute is a valid exercise of congressional power, the president's excuse for his illegal act cannot be sustained. Number one, background. The statutory and procedural background relevant to resolving this dispute is summarized below. So again, we'll just kind of walk through this so that you know why this court has the authority that it has. A, statutory background. The National Labor Relations Board was established 90 years ago by Congress in the National Labor Relations Act in response to a long and violent struggle for workers' rights. Congress sought to protect industrial peace and stability in labor relations and thus created a board to resolve efficiently labor disputes and protect the rights of employees to self-organization, to form, join, or assist labor organizations, and to bargain collectively through representatives of their own choosing. And citing case law with that, the NLRB is a bifurcated agency consisting on one side of a 5-member quasi-judicial board that adjudicates appeals of labor disputes from administrative law judges or ALJs, and on the other of a general counsel, a GC, and several regional directors who prosecute unfair labor practices and enforce labor law and policy. Citing case law here, the NLRB generally addresses labor disputes as follows. Upon the filing of a charge by an employer, employee, or labor union, a team working under the regional director will investigate and decide whether to pursue the allegations as a formal complaint. And we have footnote 6 here. The initial request made by the employee, union, or employer is referred to as a charge. Only the director issues a complaint. So that was some language clarification here. If the parties do not settle and the director formally pursues the complaint, the director will issue notice of a hearing before an ALJ. And then we're citing statute and further case laws. Number 7, if the parties do formally settle after issuance of a complaint, board approval is required. So again, the judge is just taking us through the labor law process. If necessary, after issuance of a complaint, the board may seek temporary injunctive relief in federal district courts while the dispute is pending at the NLRB. And then citing different case law. Here, we're still citing case law. The order will become the order of the board unless the parties file an exception. If the parties file exceptions requesting the board's review, the board will consider the ALJ's recommendation, gather additional facts as necessary, and issue a decision. The board may craft relief, such as a cease and desist order to halt unfair labor practices, or an order requiring reinstatement of terminated employees. These orders, however, are not independently enforceable. The board must seek enforcement in a federal court of appeals and may appoint attorneys to do so. Here, we're citing again case law, noting compliance with the board order is not obligatory until entered as a decree by a court. And again, this gives you a glimpse into how our administrative law system works. Aside from adjudicating disputes, the board may also conduct and certify the outcome of union elections under 29 U.S. Code Section 159 and promulgate rules and regulations to carry out its statutory duties. Although both the board members and the GC are appointed by the president with advice and consent from the Senate, only the board is protected from removal at will by the president, who's authorized to remove a board member upon notice and hearing for neglect of duty or malfeasance in office, but for no other cause. So this is it right here, everyone. He can remove people. It just has to be for proper cause. Such restrictions were intentional. Much like many other multi-member entities, the board was designed to be an independent panel of experts that could impartially adjudicate disputes. Citing for the case law and a Cornell Law Review, describing the NLRB, a classic example of an agency designed to be independent. Board members serve staggered 5-year terms, and the president is authorized to designate one board member as chairman. And then citing specifically to 29 U.S. Code Section 153A. So again, this is all statutory. This is all written in the United States Code. In practice, the board is partisan balanced based on long-standing norms, though such a balance is not statutorily mandated. So, again, it's not written in the law, but that's kind of what they do. B, factual background. 250 years, you bet. Yep, there's a lot of that. As set out in plaintiff's complaint and statements of material facts and undisputed by defendants, which again means that they admit it, and admissions, are kind of important. Plaintiff Gwen Wilcox was nominated by President Biden and confirmed by the U.S. Senate to a second 5-year term as a member of the NLRB in September of 2023. Shortly after taking office, President Trump moved Marvin Kaplan, a then sitting board member and a defendant in this case, into position of chair, replacing the plaintiff. President Trump then on January 27th terminated plaintiff from her position on the board via an email sent shortly before 11 o'clock p.m. by the Deputy Director of the White House Presidential Personnel Office. The termination was not preceded by a notice and hearing, nor was any neglect of duty or malfeasance identified, despite the explicit restrictions to removal of a board member in the NLRA. So again, that's the National Labor Relations Act right here. So there was no compliance with that statute. All right, the email instead cited only political motivations, that plaintiff does not share the objectives of the president's administration, and asserted in a footnote that the restriction on the president's removal authority is unconstitutional, as inconsistent with the vesting of the executive power in the president. That's awful. That's just awful. Oh my gosh, that's so awful. That's not constitutional at all. My goodness. What's so interesting is that because they are on this huge power trip, the people doing this, like they think it's okay if they think they're not doing anything wrong. So why not just write it in the email? Well, of course we're firing you for political reasons because we can. Like they're not even hiding it. It's all out in the open because they think that they can do that. The NLRB's Director of Administration, who reports directly to Mr. Kaplan, began the termination process, cutting off plaintiff's access to her accounts and instructing her to clean out her office. The board already had 2 vacancies, and now, without the plaintiff, is reduced to only 2 sitting members, one short of the 3-member quorum required to operate. Wow, so by pulling her, they couldn't even have a quorum to go forward with their job. That's yikes. Removal of plaintiff has thus stymied the functioning of the board. So, plaintiff filed the instant suit challenging her removal and requesting injunctive relief against Mr. Kaplan so that she may resume her congressionally mandated role. Recognizing that this case involves a pure question of law, plaintiff moved for expedited summary judgment on February 10th of 2025, and defendants responded with a cross motion for summary judgment with briefing completed on a condensed schedule. So as a side note, in case you're not sure what a motion for summary judgment is, it means in our administrative processes, in our civil processes, that the judge doesn't even need to have a full trial. Like a full trial is not even needed. the evidence that is needed in order to answer the question has already been shown to the judge. So her motion was saying, I would like a motion for summary judgment, putting me back on the bench or putting me back in the board. Meanwhile, the defendants said, we want a motion for summary judgment because she was fired and you need to respect that. And so they filed a cross motion for summary judgment. The judge went with her motion for summary judgment to put her back on the board. I'm not going to kind of hide the lead here, but that's what's going on here. Is we didn't have a full trial. We didn't have the pomp and circumstance of that because we didn't need it. We needed the legal decision here. All right, legal standard. Summary judgment shall be granted if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. And that is Federal Rule of Civil Procedure 46A. A fact is only material if a dispute over it may affect the outcome of the suit under the governing law. Factual disputes that are irrelevant or unnecessary do not affect summary judgment determination. And here, the defendant agrees with all of the information that the plaintiff said. So the plaintiff was like, 1, 2, 3, 4, defendants did, and it was wrong. And defendants said, yep, we did all of that. It's not wrong. Like, they're not even trying. A plaintiff seeking a permanent injunction must demonstrate 1, that it has suffered an irreparable injury, 2, that remedies available at law, such as monetary damages, are inadequate to compensate for that injury, 3, that considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted, and 4, that the public interest would not be disturbed by a permanent injunction. And we've seen these over and over and over again, these 4 parts to the test regarding an injunction, just a million times, because of we've got 115 lawsuits filed against the Trump administration, and 3/4 of them all have temporary restraining orders or temporary injunctions requested. So these are the 4 pieces used to make that determination. Discussion. In the 90 years since the NLRB's founding, the president has never removed a member of the board. That's pretty profound language also here. Oh my gosh. Never. No one's ever been removed from the board. His attempt to do so here is blatantly illegal, and his constitutional arguments to excuse this illegal act are contrary to the Supreme Court precedent and over a century of practice. So that's pretty forceful language. For the reasons explained below, plaintiff's motion is granted. Plaintiff's termination from the board was unlawful, and Mr. Kaplan and his subordinates are ordered to permit plaintiff to carry out all of her duties as a rightful presidentially appointed Senate-confirmed member of the board. Here's Section A. Now, this is the second person. We had another one. We had another woman that I have already read her case too, and she was also put back on a board that she had been pulled from. So this is the second one, but I think it's just very well written. Humphrey's executor and progeny are binding on this court. So the Humphreys executor case is what's setting out our standard here. What we're looking for with all of our cases are precedent and tests, and then the judges will put the facts of each individual case, plug them into those factors in the test, and determine whether or not they pass. If they pass, then that's the direction you go. And so Humphrey's executor is another one that sets out that test that we're looking for. The board is a paradigmatic example of a multi-member group of experts who lead an independent federal office. Since the early days of the founding of this country, Congress, the President, and the Supreme Court all understood that Congress could craft executive offices with some independence as a check on presidential authority. That understanding has not changed over the 150-year history of independent multi-member commissions, nor over the 90-year history of the NLRB. The Supreme Court recognized this history and tradition in Humphrey's executor. This case was in 1935. Good morning. In upholding removal protections For such boards or commissions, and this precedent remains not only binding law, but also well-reasoned reflection on the balance of powers between the political branches sanctioned by the Constitution. Number 1, removal restrictions on the board members are well grounded in history and binding precedent. As a textual matter, the Constitution is silent as to removals. Consequently, though, Article 2 grants the President authority over some appointments with advice and consent of the Senate, and vests in him the executive power. Article 2 contains no express authority from which to infer an absolute removal power. I think that conclusion is incredibly important to remember also. So this removal power, this removing of people, that's not set out under the president's job. It's very well written, I agree. Yes, of course. So here we go. I'm going to skirt down here. The Supreme Court has held that a general power to remove executive officers can be inferred from Article 2, yet the contours of that removal power and the extent to which Congress may impose constraints are nowhere clearly laid out. The courts in such cases must therefore turn to established precedent, judicial decisions, as well as general practice and tradition. The Supreme Court has repeatedly recognized that traditional ways of conducting government give meaning to the Constitution, citing a lot of case law here. And the Youngstown Sheet case is one of the biggest presidential powers cases. If you're interested in pulling up the presidential power situation, that's when Truman took over the steel mills. Thus, in separation of power cases, this court often puts significant weight upon historical precedent. And citing multiple other cases as well. Even when the validity of a particular power is in question, the court will, in determining the existence of that power, give weight to the usage itself, citing further case law, and hesitate to upset the compromises and working arrangements that the elected branches of government themselves have reached. Justice Frankfurter, in his seminal concurring opinion in Youngstown, declared that systematic unbroken practice could even be treated as a gloss on executive power vested in the president. Not only are there removal protections on members of the independent multi-member boards, like the NLRB, supported by over a century of unbroken practice, but they have also been expressly upheld in clear Supreme Court precedent. Since 1887, Congress has created multiple independent offices led by panels whose members are appointed by the president, but removal only for cause. And then citing multiple statutes where that is involved. The Supreme Court explicitly upheld removal restrictions for such boards when considering removal protections for the commissions of the FTC in the Humphreys executor case in 1935, while also recognizing the president's general authority over removal of executive branch officials. The court noted that commissioners of the FTC, like the Interstate Commerce Commission, are called upon to exercise their trained judgment of a body of experts appointed by law and informed by experience. Congress, having the power to create such expert commissions with quasi-legislative and quasi-judicial authority, must also have, as an appropriate incident, power to fix the period during which they shall continue and to forbid their removal except for cause in the meantime. So you can see why this is so incredibly important, that you can't just pull these people off these boards, right? 2 months later, with the guidance supplied in Humphrey's executor and following the model of the FTC as endorsed by the Supreme Court there, Congress established the National Labor Relations Board. Both entities, the FTC and the NLRB, have 5-member leadership boards with staggered terms of several years, minimizing instability and allowing for expertise to accrue. Both were intended to exercise impartial judgment. And then quoting where that is, the board, like the FTC, is predominantly quasi-judicial and quasi-legislative in nature, with the primary responsibility of impartially reviewing decisions made by ALJs, so those administrative law judges. Yes, thank you, VC, thank you. In fact, the board does not prosecute labor cases nor enforce its rulings. The side of the NLRB managed by general counsel, who is removable at will, so this one he can pull general counsel if he wants, by the president, carries out those more executive powers. And then citing the code itself, 29 United States Code Section 153D. Again, and we're finishing quoting that. As plaintiff correctly states, the board closely resembles the FTC and is thus squarely at the heart of the rule adopted in Humphrey's Executor. Numerous other offices have followed the mold of the NLRB and FTC with multi-member independent leadership boards. Protected from at-will removal by the president. And we've got multiple citations here. Here's a quote. Since the Supreme Court's decision in Humphrey's Executor, the constitutionality of independent multi-member agencies whose officials possess some degree of removal protection that insulates them from unlimited and instantaneous political control has been uncontroversial. So there's that, and then further case law supporting that. Long settled and established practice is a consideration of great weight in a proper interpretation of constitutional issues of separation of power. And then you have footnote number 9. Defendants protest the reliance on history and tradition because the independent multi-member commissions date back only to the late 1880s. Such a practice comes far too late to provide reliable evidence of the original public meaning of Article 2 of the Constitution's separation of power in defendants' views. That in no way invalidates the significance of long-standing tradition, however, which is probative even when the nature or longevity of the practice is subject to dispute, and even when that practice began after the founding era here. Relying on post-Civil War practice. So the defendants are saying late 1800s isn't far enough back. And the judge is like, all right. Recent consideration of the constitutionality of the removal protections for the NLRB members have accordingly upheld those constraints on presidential removal authority under the Humphrey's Executor case. And then, oh my gosh, and then all of this case law as well. This is what we would call a string citation. Courts have also recently upheld restrictions on removal under Humphrey's Executor for other multi-member boards, such as the Consumer Product Safety Commission. So that's already been used. And the same has been true for the FTC. A court in this district has also upheld removal protections for the Merit System Protection Board. This was the case that I was referring to earlier, everyone, that I have read before, where this woman was pulled off of her board also, and the court said, no, put her back on. Put her back on the board. The 150-year history and tradition of multi-member boards or commissions and 90-year precedent from the Supreme Court approving of removal protections for their officers dictates the same outcome for the NLRB here. So again, you take a minute to pause, everyone, right? Because one of the first things that we think about is if this case makes it all the way up to the current U.S. Supreme Court, what are they going to do? Are they going to uphold it, or are they going to reverse it? And what the judge is doing here is setting out line by line the historical precedent that sets out that the term of this woman's employment, and that it should not have been halted like this, and that is antithetical to what the whole purpose was of the board. So I think the judge is doing a really good job of saying, hey, you guys want to go against 150 years of tradition here? All right, so that's why I think this is so well written. Number 2, defendants' argument that Humphrey's Executor does not control fails. Now I'm going to skip through this second piece here where they go into further detail on the Humphreys executor piece, just because I don't think that particular part of it's essential to understanding how the court came to its decision. So I'm going to just skip through here that second element in the Humphreys case. All right, number 3. We've moved here. Defendant's argument that Humphrey's executor has been repudiated and is no longer good law is not persuasive. So we'll pick right back up here, all right, on page 19. Fundamentally, the position of defendants and their supporting state amici, which means a friend of the court, so people who believe they've got specialized knowledge, will file an amicus brief with the court, and so to give that court extra references, extra knowledge. Urging this court to not apply Humphrey's executor stems from the reading of the Supreme Court's subsequent case law as repudiating the precedent, and we're citing Thomas's concurrence in part. Here's Tennessee's amicus brief. So again, they're the ones that had quoted the Britain's king gets to do it, so why can't we do it? Then 20 states amicus briefs again. Defendants therefore argue that Humphrey's executor must be read extremely narrowly, despite that whatever little remains is binding on this court. To the contrary, an unbroken line of cases since Humphrey's executor has reinforced the constitutionality of removal restrictions on multi-member expert boards, and the pre-Humphrey's executor history demonstrates that this decision was well-grounded and in accepted principles of checks and balances. So again, just backing up. Easy. No, Thomas. Oh my goodness. So just backing up again that case that is being relied on here. Post-Humphrey's executor case law reinforces its central holding. In every case following Humphrey's executor, the Supreme Court has preserved the constitutionality of removal protections on independent multi-member boards and commissions. Shortly following Humphrey's executor, in the Weiner v. U.S. case, the court held that the Constitution did not grant the president authority to remove members of the multi-member War Claims Commission for no reason other than he preferred to have on that commission men of his own choosing. 30 years later in Morrison, the court again recognized the exception to the president's removal power for officers with adjudicatory powers, but further explained that the permissibility of removal restrictions did not turn on whether the officers' functions were quasi-legislative or quasi-judicial, as opposed to executive in nature, instead looking to the degree to which they impeded the president's ability to execute the laws. And with that, I will skip a little bit further. Again, this analysis of Humphrey's executor is very important for the Supreme Court, but we don't need it in order to understand the case. So we'll just kind of go through. Here we go. Next, presidential removal power has never been viewed as unrestricted. So I think this is one of the key sections that is important for precedent, for reliance on by other courts. Because again, there are 115 cases filed against the administration here. Defendants and their supporting states amici go even further in suggesting that not only has Humphrey's executor been repudiated over time, but the opinion was also wrong at the time it was decided. And then he's citing where that all was put in there. They are again misguided. While the Myers Court made clear that the president has a general removal power for executive officials, defendants' myopic focus on this case loses sight of the limitations in its holding, a point driven home in Humphrey's executor, decided less than a decade later. Nothing in the Constitution or the historical development of the removal power has suggested that president's removal power is absolute. In fact, the history upon which Myers relies and immediately following Supreme Court decisions undercut any view that Congress, when exercising its constitutional authority to shape executive offices, is completely barred from conditioning the president's exercise of his removal authority. So again, there's no absolute power here. I feel like Mr. Trump is really looking for that absolute button that he can push, but there is none. There's no absolute immunity. There's no absolute power to fire people. He just doesn't have absolute power on anything. And that is, the way that the government was designed, was he wasn't supposed to have absolute power. In Myers, Chief Justice Taft, the only person who has served both as a president and a justice on the Supreme Court, recounted and relied on the history of the decision of 1789, a congressional debate about the president's removal powers during the first Congress to declare unconstitutional a statute requiring the advice and consent of the Senate for both appointment and removal of federal postmasters. And we've got a footnote 14 here. The statute regarding removal of the postmasters read, quote, postmasters of the first, second, and third classes shall be appointed and may be removed by the president by and with the advice and consent of the Senate, and shall hold their offices for 4 years unless sooner removed or suspended according to law. The first Congress had created the first three executive departments, the Department of Foreign Affairs, War, and Treasury, and after much debate, ultimately granted plenary removal power to the president over the Secretary of Foreign Affairs, and crafted that agency to be an arm of the president. The first Congress did not make clear whether the decision to grant the president plenary removal authority over the Secretary of Foreign Affairs derived from the Constitution, or rather was granted by Congress's own prerogative. Of course, we have to remember this was George Washington in that situation where he was like, just write whatever you want, and that's how we'll do it. He wasn't much of a fighter for what he thought was best. He just wanted to hold everybody together, hold the country together until he could, be done and go back and retire. He's like, I'm done, man. I did everything I could. All right, enough of that. The summer of 1789 thus ended without resolution of the critical question: was the removal power beyond the reach of congressional regulation? And it looks like we've got another law review article here stating, well, we don't know. Some clarity in the first Congress's view may be gleaned, however, by the disparate approach that Congress took with respect to the Department of Treasury. And of course, that's where Alexander Hamilton was, seeing the Treasury as a department less intrinsically tied to core executive powers enumerated in Article 2, like that over foreign policy. Congress gave far more direction to the structure of that department, specifying in detail its offices and functions, and granting independence from unfettered presidential removal power to the comptroller. Yes, hello, Tay. Welcome in. In short, the executive branch was not treated as strictly unitary, but rather as a branch with units of varying degrees of independence and generally subject to congressional direction through checks and balances, including on its personnel. So I remind everybody too, I think this is right. I think we're at the 119th Congress. So if you look, just crunch the numbers, we're only at 119. We're still pretty young here. We're still pretty young country, still trying to figure out how the government works. So, we're kind of in that stage now where we're trying to figure out what the boundaries are as well. Chief Justice Taft and Myers cherry-picked only one portion of that 1789 story by highlighting what the first Congress did with the Department of Foreign Affairs. Hold on, puzzle piece, everybody. Did we get it? We did, yay. All right. And then that is 272 U.S. at page 113. So that Myers case, again, is a pivotal case, everyone, to take a look at. We've got Kagan dissenting here. Despite the structure of the post office far more closely resembles the Treasury Department of 1789 than the Department of Foreign Affairs, Chief Justice Taft ignored the actual nuances reflected in the decision of 1789 as to congressional power to condition the president's removal power reflected in the treatment of the new Treasury Department and instead read this history, quote, through executive colored glasses, end quote, to support, quote, his strong preconceptions, end quote, as former president, quote, about presidential removal power, end quote, to reach the conclusion that a regional postmaster could not be subject to removal protections. So again, the reason why Taft is being brought up here is, I think, really important, and what also makes that Myers case so essential is because of that dual role that he played on the court as well as president. All right, skip. Dicta in the lengthy Myers majority opinion made broad pronouncements about the importance of the presidential removal power that were both contradictory and opposite. While Chief Justice Taft promoted the benefits of recognizing vast presidential removal authority on the one hand, he recognized that Congress could legislate around appointment and removal of principal officers, in some circumstances, and inferior officers refusing to threaten protections for the civil service. So what Taft is saying here is that, Congress can also come in and set some boundaries here, is what Taft is going into in that decision as well. Only 9 years later, in Humphrey's Executor, the Supreme Court, consisting of 6 of the same justices who participated in the Myers decision, Sutherland, Van Devanter, Brandeis, Stone, McReynolds, ooh, that guy was a jerk, and Butler unanimously retreated, denouncing the idea of an illimitable removal authority and disavowing Myers's abundant dicta. Just watching my terminology here, but that just means extra goings-ons that the judges feel like sharing that's not essential to the opinion here. So that's just my humble opinion on McReynolds. Yikes! Oh my goodness. Justice Sutherland, who authored Humphreys, despite joining the majority opinion in Myers, limited Myers to the narrow point that the president has power to remove a postmaster of the first class without the advice and consent of the Senate, as required by Act of Congress, and wrote that other expressions are beyond the point involved and therefore do not come within the rule of stare decisis. Now, stare decisis means let the decision stand, and it's another way of saying we rely on precedent. When we're looking at a particular case, we also look back at how these kinds of cases have been decided before. So let's skip ahead a little bit here so that we can, I don't know that we really need to go into that much more a description of the Myers case, but it does look like we've got Brandeis's, a bit here on Brandeis. So let's hop down there. So again, regarding Humphreys, we'll just kind of curve back around to this footnote here. Justice Brandeis's dissent in Myers was not so broad as to authorize Congress to restrict presidential authority over removal of anyone in the executive branch. Here, rather, he focused on the fact that the postmaster was an inferior officer, very unlike the Secretary of Foreign Affairs, and the mischief that would result if the majority decision were read to endorse absolute presidential removal authority for all officials. So Brandeis was like, dude, if you give that ultimate authority, we're going to have troubles here. So the takeaway from Myers is therefore discreet and uncontroversial. While Congress may structure executive branch offices via statute and legislate about the roles of the executive branch officers, including standards for the removal, Congress cannot reserve for itself an active role in the removal decision. So this again is the key piece, everyone. They're saying you can say how to remove them, but you don't get to come in and say we agree with that removal or not. You can write the rule, and here it is, 5 years. So 5 years you expire, you're done, but you can't come in and say, well, we don't approve of this person. All right, is everyone kind of following that rationale here from the Myers case? Everyone's like, who cares? Why is this happening? The world's on fire. I don't care about separation of powers. Oh, I don't blame you. All right. In short, neither the founding era history nor Myers can carry the heavy weight that the current president has thrust upon it. Here from a letter of the acting Solicitor General. In Myers, the Supreme Court recognized that Article 2 of the Constitution gives the president an unrestricted power of removing executive officers. Neither supports the view that the president's removal power is illimitable. Whatever the benefits of unrestricted removal authority under certain circumstances, the framers did not constitutionalize presidential control over all that is now considered executive. They did not believe that the president must have plenary power over all we now think of as administration, and neither did the early 20th century Supreme Court. So again, that's incredibly powerful language here. All right. So when Mr. Trump's like, I can do whatever I want, it's like, well, you can actually. You really can't do whatever you want. Oh, well, yeah. Right. All right, so we're going to skip down here. Again, the Humphreys executor case remains binding, so the court is saying you can't just get rid of it because you want to. Oh, you're absolutely welcome. And we'll hit B here, and we're actually just coming down to the last couple of pages here of this decision, and this is where the court sets out the remedy. All right, so the remedy for for the person here who was pulled, so Miss Wilcox. Sorry, everyone, I had to scroll over here to get my tea. All right, we're scrolling back. I'm always worried that I'm going to get a cattail under the wheel, but we're okay. Plaintiff is entitled to permanent declaratory and injunctive relief. Permanent. That's a big point, too, to keep in mind. The difference between all of our temporary injunctive reliefs or temporary restraining orders, this is a permanent order that is set into place. For all of these reasons, plaintiff prevails on the merits and is therefore entitled to declaratory ruling that she was unlawfully terminated from her position as a member of the board. Defendants concede as much. And then actually citing the transcript where defense counsel stated, quote, "We're not fighting this requested declaratory judgment," end quote. Again, yeah, we agree with everything the plaintiff's saying. I'm not sure that's all right, whatever strategy that is. Plaintiff further requests injunctive relief against Mr. Kaplan, ordering him to allow plaintiff to carry out all of her duties. To demonstrate that injunctive relief is warranted, a plaintiff must show 1, she suffered an irreparable injury, 2, remedies available at law are inadequate to compensate, 3, a remedy in equity is warranted considering the balance of the hardships to each party, and 4, the public interest is not disturbed. Notwithstanding plaintiff's success on the merits, defendants contest her entitlement to injunctive relief. So then they're going to go through each of those elements, everyone. So the plaintiff's irreparable harm and inadequate remedies at law, and explain why that part of the test has been satisfied. So go through that explanation, and then I feel like these pieces of this test just over and over and over again, probably because I keep reading all of these cases. And then the balance of equities and public interest and why that's important again in granting this permanent injunctive relief here. So again, look at this footnote here. I'm just going to take a moment to be like, if you gave this to me with this footnote, this is just one footnote here, sir. Can you make the print a little bit bigger? All right, I digress. And skipping through again. So all of the 4 pieces are met for that permanent injunctive relief. So we do have a couple of things about the Supreme Court because, of course, the defendants have appealed. So finally, defendants predict their ultimate success before the Supreme Court, warning that if the plaintiff is allowed to resume her duties on the board now, any NLRB decision in the meantime may be voidable, and the NLRB will be under a heavy cloud of illegitimacy, which again, they don't even have enough people there to have a quorum, so whatever. Suggesting that reinstatement hampers effective governance by causing intra-office chaos and questions about the fitness of the official. The possibility of future changes in the law is not enough. However, the permit to permit an unlawful termination and the halting of all board activity in the meantime. Plaintiff's wrongful termination has caused chaos enough and shall not be allowed to stand based on defendants' self-serving speculation. Woo, that's some harsh language. Oh, thank you so much, Marlene. I appreciate that. Harsh language. Here's our conclusion. The president seems intent on pushing the bounds of his office and exercising his power in a manner violative of clear statutory law to test how much the courts will accept the notion of a presidency that is supreme. Wow, that's, oh my goodness, yeah, woo! Not playing around there. Defendants cite in their briefing Trump v. U.S., granting president absolute and presumptive immunity from criminal liability for official acts because, of course, they always quote the immunity case, right, to argue that the removal power is conclusive and preclusive, with the result that the president need not be subject to criminal or civil legislative constraints. Let's see what the judge has to say about that. The courts are now, again, forced to determine how much encroachment on the legislature our Constitution can bear and face a slippery slope towards endorsing a presidency that is untouchable by the law. Ooh, that's fire. That's fire right there. The president has given no sufficient reason to accept that path here. Humphrey's executor and its progeny control the outcome of this case, require the plaintiff be permitted to continue her role as a board member of the NLRB and her termination declared unlawful and void. The Constitution and case law are clear in allowing Congress to limit the president's removal power and in allowing the courts to enjoin the executive branch from an unlawful action. Defendants' hyperbolic characterization that legislative and judicial checks on executive authority, as invoked by the plaintiff, invoked by the plaintiff, present extraordinary intrusions on the executive branch, is both incorrect and troubling. Oh dear. Also troubling. Yikes. Under our constitutional system, such checks by design guard against executive overreach and the risk such overreach would pose of autocracy. And then citing Brandeis again, an American president is not a king, not even an elected one. Ouch! Footnote 24, motion hearing on March 5th, transcript at 43-9. Plaintiff's counsel highlighting the constitutional role of the other branches in checking the president's authority and his power to remove federal officers and honest civil servants like plaintiff is not absolute, but may be constrained in appropriate circumstances as are present here. An order consistent with this memorandum opinion will be entered contemporaneously and then signed by Judge Howell. Woo! Goodness gracious, everybody. Woo! That's a pretty solid, very solid decision. Very, very, very solid. I'm incredibly impressed with this judge. Never forget oh, thank you, Sabirio. Oh, thanks. That's so sweet of you. This is pretty powerful, everyone. Yeah, Howell is amazing. Thank you, Aaron. Yes. So again, we've got 115 cases going, and I'd say maybe 15 of those cases have to do with these firings of all of these different people. So, this is nice to have this precedent set out. Again, this is a permanent order, so this isn't temporary. We've got a lot of temporary orders out there in these other closet docket cases. Is this I cannot think of a time, even, I guess Mr. Trump's first administration had a lot of lawsuits filed, but nothing like this. Like, I've almost run out of closet door space. I was in there trying to add new orders and new decisions in there, and I'm just like, oh my gosh, just looking at it, it's like, it's a lot. It's a lot. It's so much. Who appointed this judge? I don't know. I have no idea. Federal judge, have no idea, but it's a life appointment. I know. Oh, good. I'm so glad. Yeah, of course, of course. I've got my green nails for today. Oh, Lisa, no problem. I'll be putting this up on my Tube of You later. I've been posting over there a couple of times. I'm trying to do up to 4 times a day over there. So, can we do a closet door tour again? Sure, absolutely. I can't do it at the moment, but yes, I've got a few more cases I want to get done. We just had some of the transgender paperwork that's been filed on that. We've got some frozen funds cases that have come out. So yeah, I've got some updates over there for sure. TikTok's I know. It's not the best. Appreciate that you share. Oh, of course, yes. And again, these are my thoughts on different things. And I try not to sprinkle too many of my own personal thoughts in here, but there's also good information to just gather as foundational pieces you may not have known about legally. So now you do. Obama, yeah, I'm not sure. I thought it was a dude. I mean, it doesn't matter. I've just been referring to it as the judge as a dude, but I should say they because I don't know what it is. So I apologize. Judge Howell, however it is, I apologize. Oh my gosh. So, right, I do need to do a closet docket. I'm wondering about doing it on YouTube later today. I may do that, but I'm not sure yet. 634. Okay, I can look it up. Sure. Is this a new one? Divide the Ninth Circuit. That's gonna be tough. Okay. Yeah. Okay. So I'll probably do that then on YouTube then later. I do want to get up onto YouTube today, I'm hoping. Again, I'm just kind of a bit behind on everything, but instrumental in getting really? Okay. Oh, we love that. All right. We love that. Well done. Well done, you. I just think it's great when the judges are just like, we're not going to play around. We're going to call a spade, and, that's what we're dealing with, and that's what we're dealing with. And, her style of writing is very easy to read, and I just love the historical context, so can only hear headlines from you. Well, I do try to get my headlines in every day. Hello, Virgo empath. Hello. Who can change what circuits cover? So it's up to Congress. Congress can add, different bits and bobs. It's up to them to set out the courts and the circuits. So if they can get through both houses, and they can do that. Thank you so much. Oh, you're welcome. You're welcome. Yeah, I've kind of been off of the radar for the last few days, but trying to make it come back here before Musk threatens to impeach this judge. It's a good question. And, people are starting to get kind of upset at Mr. Musk. Is anyone noticing that? Has anyone noticed that? That he's kind of I think it's great that he's personally being named in a lot of these lawsuits. So he's not just being, the Doge is the only one getting called out in the lawsuits. It's his name is on a lot of these. Would he have the authority? He doesn't have any authority. The only authority he has is when he forces something to be done and then says later, like, whoops, that's really it. So none of this is normal, everyone. And, I'm not going to normalize it. I'm not going to say, well, this is just how it works now. Because no, this is not how it works. This is not how it works. So we have to make sure we call that every day. We got to call it out every day because there's a lot of stuff happening every day that should not be happening here. Yeah, not the oops, exactly. Oh my gosh. How many billions are we paying to fight the Constitution? Great question. Oh my gosh. And I can't remember what case it was, but I just put a case that was filed. It was just filed a couple days ago. And it was so interesting because the attorney out of the DOJ that had, had been assigned to the case put in their appearance, and then in 24 hours they put in like their withdrawal request. I'm like, you guys can't even for 24 hours get the right attorney in the right place at the right time. The DOJ is just like a giant mess right now. Oh my gosh, Republicans will pack the court. Well, I mean, everybody does that. Everybody, it doesn't matter. Whomever is in power, and I'm not saying it's right or wrong or good or bad, whoever is in power packs the courts. That's just what's done. That's, the same thing that happened with, John Adams and Jefferson. I mean, everything got packed all the time. That's been a long-standing tradition since, 1800. That's just, what we do over here. Until we change how judges are appointed, that just won't change. It's set up in the Constitution, and whoever's in power will try to pack the courts. Yep, that's how it works. Again, and I'm not saying I'm for or against it. I'm just, calling it for what it is. It's called packing the courts, is what they do. So that will continue to go on without a doubt. And this question of, trying to impeach judges, I mean, again, it's wasteful, because you really have to have a high crime or misdemeanor or some kind of a really big issue in order to justifiably impeach a judge. Other than that, it's just a waste of time. Yeah, if they're not corrupt. Well, I think the question is how do we define corrupt? And then how do we prove corruption, and who decides, right? So there's a lot of elements that go into this idea of corruption. How long for them to get through cases? Months, years? I don't know. This case closed a lot quicker than I thought it would. This is, in my opinion, the second case that has closed, although we are on appeal. So, I don't know what's going to happen after the appeals go forward. The judge, they actually asked for a stay. So they asked to not put her back on the board until they got a decision from the appeal. And the judge was like, no, I'm not doing that. That's stupid. That's stupid. I'm not doing it. All right. We only have 2 cases that have had some kind of definitive answer at this point. But yeah, some of these cases, especially the civil rights cases, those can take months and years, depending on what exactly is wanted. If it's an injunction, meaning you want the government to stop doing something, those can go relatively quickly through the hoops. But if it's anything other than that, then it might be a problem. And then, of course, everything is being appealed by Mr. Trump's world. So nails. Oh, thanks. Yeah, I've got my green nails. It looks like they've kind of got like, I don't know, they've got 4 different quadrants, I think. I was like, what? Do we have any green ones? And we found it. 250 years of laws. Well, right. I mean, you'd think that would be important if Thomas isn't being impeached. Now, last I heard, the articles of impeachment have like fallen into the black hole of the abyss of legislation that doesn't get in front of a committee. But those articles have still been filed. I mean, they're still there. They're still existing. It's just they're kind of in the black hole right now. Oh, yeah, thanks. Got my little peacock pen going here today. Comfort with Russia withholding. Very difficult to prove, Eddie. Eddie. I would say this question of any kind of treason question right now is going to be incredibly difficult to prove right at this time. It just is. It's hard to prove normally, and right now with what's going on, it makes it even more difficult. And I'm not saying that it's not treason or that it's not important. I'm saying find a better crime that's easier to get through the system than treason. And that's from a prosecutor's point of view. If it's a really rough road, find a smoother road to take it down. So there are a lot of other things that can be put into place. And you might say, well, with the president, you got to have treason or nothing. And, to some degree, that's true. But it's tough. It's tough. Yeah, I mean, it's a valid question. And there's a lot of harm that's being done. Like a lot of harm. And it's heartbreaking. But yeah, I think that's treason's going to be a tough road. And too, that was one of the thoughts that I was having when I was looking at the Democrats with their little paddles, when they were like, no, and just holding up their little paddle. And I'm wondering if part of it is because of the government's flipped. And so it would be pretty easy to kind of bulldoze in there and say that there was some kind of like insurrection. I mean, honestly, because we don't really know the parameters of how far this government's willing to take that kind of bad behavior. Right. So we just don't know. Need to protest like France. Well, that was a specialty group, and I completely back them. I myself will not be protesting that way. But I think France does great. I tell you what, with the French, okay, I'm not going to generalize all French people, but I will say, when it comes to revolution, that French history is going to do nothing but help you figure out how that goes down. They do good work there historically. But yeah, there's a lot of stuff going on in the whole world, There's a lot. June Marie, you've got a valid point too. I mean, this is one of the most stressful jobs in the world, and nobody leaves unscathed. And I think that's why a lot of what he's doing is being delegated to someone else. But what actually happens, we just don't know. Much smaller country. Exactly right. We have to be more creative. You're exactly right. Yep. Mm-hmm. Yep. Farmers need to bring manure to DC. Oh, well, yeah, because I don't know. I mean, they probably would need money for gas right now. The farmers need money for gas, everybody. Impeachable offense. Yeah, and I agree. The kicker here isn't that, there's going to be no reason to bring impeachments or no wrongdoing. The key is going to be who in Congress, gets a spine and decides to stand up for the Constitution, rather than, some kind of glory for their higher up people. Because the peons, the ones at the bottom of the pyramid, they're not going to get a lot of benefit by kissing the ring, There's not a lot of benefit coming to them. But the numbers count. Like all of those peons at the bottom are still votes counted for passing or refusing to pass certain bills. So like if those, peons could figure out that they actually have a lot of power and get together because they need to know that the higher ups aren't going to share that power, something might happen. But, and it's not necessarily about his followers. It's about, elected people that took an oath to the Constitution. And they can say, well, if I want to be part of this club, I've got to vote the way that they want me to vote. So, like a fraternity situation. And it's like, what's more important to you, your fraternity or your oath to the Constitution? So that's how I look at that. Right, Grammy. Yep, you got it. Hopeless? Well, I don't think anything's hopeless yet. I'm not hopeless yet. We're not at bunker. No, it's not hopeless. Oh no. We're doing great actually. If you look, we're doing really good. I know everybody feels like we're not, but 115 lawsuits. All right, we're keeping the DOJ busy, so they're not able to go out and start trouble, first of all. Second of all, did anyone see like that VP guy? I can't remember his name, but the pudgy guy with the beard out there with the memes? I mean, and getting like, called after? That was huge. Vance. I forgot his name. Sorry, forgot his name. The situation with Vance, that was huge. That's huge, everybody. That he was out thinking he could just walk through his daily routine and no big deal. And people called him out on his bad behavior. That's amazing. More of that needs to happen. Go find out. There's this group that's like, where do they go to church? Find them at their church. And I'm like, well, everybody has to make their own decisions, but that's what you do. You're like, hey, dude, you made a rough decision here. Why don't you tell me why? And he's like, well, I'm just trying to get some pizza. Like, too bad for you. I'm going to spoil your pizza party by talking to you about your bad choices. There's a lot of ways to get somebody held accountable. A lot of ways. Yeah, he went to Vermont. Well, yeah, exactly. And none of that's illegal. And it doesn't need to be. And it doesn't need to be aggressive. It doesn't need to be harassing by any means. They were, and I saw the people that were involved. And they said, hey, what are you doing here with the Ukraine? And he was being all rude, and it's like, no, what are you doing? Here's the question. Answer the question. Why can't you answer the question? And going to the town halls and all of that, perfectly within your purview, your freedom of speech. Absolutely. There's no need to go down an ugly road like, others. It's just those kinds of questions. One of the things that I think was so fascinating is when a reporter asked Mr. Trump a question and he's like, you shouldn't be asking me that question. Like, he snaps at the reporter. That means the question itself has gotten under his skin. So the fact that there were people asking him questions got under his skin. Yeah, it's like, hi, you don't get to just fade back into the background, or have absolutely no accountability for what you said. So can you talk about the person ICE took from Columbia University? I don't have a lot of information on that right now. I just don't. But let me put that on my list here. I'm hearing things about it, but the big issues that I've been trying to work with on ICE right now have been the big cases for ICE coming into the Quakers meetings and into the schools. That's where my attention's been. Do you think he's really planning on a martial law declaration? So that's so complicated in this country, though. Hold on, let me write down the university one before I forget. University ICE situation. So I don't forget to pull that up. Martial law in the United States is weird. It's weird because we have a lot of things in place to make it so that they can't do that. And we did that on purpose. So we do have the suspension of habeas corpus. We do have the declaration of an emergency situation, which, I think Trump did before with the border wall in order to get some funding for that. I mean, it's like already been done a bit. But he can't really do too much damage without the help of Congress. That's really the key. He's got to have Congress come in and pre-approve a lot of stuff. He can declare that emergency, but as far as shutting everything down and those kinds of things, like if you're talking about the War Powers Act and that kind of stuff, you got to go through Congress in order for that to truly come into place. So it is possible. Don't get me wrong, but it's more complicated. It's not like the South Korea situation that we saw earlier, where it's like, that's it, and then military goes out. That's not how it is. There's a procedure, rules and regulations that have to be followed, and you're like, well, he's not going to follow them. Like, well, if he doesn't follow them, then he gets sued. And that's why we have 115 cases and counting. So the resistance is in there. If you don't follow the rules and you don't have the proper protocol in place, then the soldiers that you're trying to command are like, dude, we don't have the authority to go against the Constitution. So, there's just a lot of different pieces to it. It's not great. It's always something that we are worried about, something we're thinking about, but it helps if you know how the laws actually work. Democracy is holding up so far. Yeah. The war is in the courts, everyone. The Civil War is in the courts without a doubt. There's some fighting going on here. Puppet chairman of the... again, those elections to keep Elon busy. Oh, I know, right? That's huge. That's a huge deal. But and as I had started to say, that we're doing great. We're doing some really good work because the decisions coming out of the courts, a couple have been, we've taken a couple of hits, but we've also taken a couple of really great decisions. This is one of the great decisions right here. The Harris decision is another one of the great decisions that has come out. We have a couple where we're like, man, I'm not so sure about that, but these cases just getting set up and knocked down, and everything's getting put on pause. So people can't just go busting doors down. A lot of that's been going on. Calling out people on the street in a perfectly legal First Amendment way. That's great. We're doing good on that. So, and this idea that Rubio was like, dude, we're trying to, what are you doing? I think that's great too. The more that the cabinet is like, this is too far, that's also great. So we've got a lot of things in place that are showing really good signs right now. All right. So as far as the woe is me and I'm getting a bag of donuts and hiding in my shelter, it's not every day of the week. Okay. I'll put it to you that way. I'll put it that way. I've got to go check on Hawk. Yeah. I'm not sure how he's doing over there. But for me, it's like, well, there's 7 days in the week and not all 7 days involve donuts. Oh my gosh. So we're going to be okay at this point. We're just getting started. Right. We're just getting started here. And again, everyone, did you see the protests? Oh my gosh, the protests over the weekend. Oh, that stuff absolutely drives him bonkers. We love that. So we're doing okay. We're doing okay. Wake me when it's over. Oh, I know, right? I know. I know. I feel that way too, but we just struggle. We struggle right now. Yeah, get out and protest if you can. If protesting isn't in your wheelhouse, that's okay. Gaining knowledge, I think, is underrepresented as incredibly important. The more knowledge you gain, the better you are to explain things to anyone else that you're talking to. That can absolutely be your superpower, is just learning what's really happening, how things really work. So if you can't get out there and you're like, dude, I can't go out there and protest, I'm with you. My protesting days are behind me. But, I can learn about what's going on so that the people around me at least know what's what. So the learning of the information, everyone, it can absolutely be your superpower in this situation as well. So don't forget that. The media covered the protest to some degree. The more I hear, the more scared I get. That's true. And you got to walk away. At some point, you got to walk away and reset. And you can't, your sources are the key here. If you hang out too much in one particular place, you got to turn it off. You got to turn it off for sure. So for me, with Midas Touch, I'm just kind of like, I'll sneak in and peek and then come back out again. I stick to the source materials. I stick to original sources. I look at the cases. I look at the dockets. I look at the laws themselves. That's what I focus on. And because I'm doing that, I feel pretty good about it. I mean, I'm not in a web of despair because I see the law itself. So that helps me a lot rather than, somebody's take on it in the media. That's helpful for me. And then I come and I share it with you all. And I just say, look, we've got laws here, and that's okay. You didn't hear, oh no, the protests have been all over the place. Oh yeah, all throughout the United States, we had all kinds of protests going on. Heck yeah. And it might be too, my state is really struggling right now. And so, the protests are going completely bonkers in my state because we're like, we need to get some stuff sorted out here. The suit for him to take over control. Yeah, I don't know about any of that. He doesn't have any control over elections. Somewhere almost every day. Absolutely. And there's boycotting going on, right? Who didn't buy from Target? And then I think it was Amazon, I think is another big one. I'm not sure who's next. But yeah, there's like a boycott every 30 days, everyone. And I'm living for it. I'm just like writing it down. So March will be no Amazon, no Target. Walmart's gone. Just pick it up. Yes, exactly. All week is tough. It is. That's a tough one. The Amazon one's really, they really kind of got us all hooked, didn't they? So I had to be conscious and be like, all right, I'm putting everything in my cart, but I'm not buying the cart, is how I'm looking at it. And honestly, it's kind of been good to do a more of a lower buy or a no buy, because sometimes I think we don't really use what we already have. And so that's been kind of my motto lately. Use what I have, because first of all, the number one thing is it's better for the environment. And the environment needs so much help right now. Like, it needs a lot. And then the no buy, low buys, those are good too. So clean for 30 days. Good for you, Kristen. Good for you. Good for you. No Amazon. There we go. We love it. Yeah, Hobby Lobby, Chick-fil-A. Yes, yes. Window shopping, yes. I think it's good. Subscriptions, yeah. I mean, again, though, you've got to kind of pick and choose what is okay and what's not okay, because at the end of the day, you still need to remain sane. So that's important. But also, in my house, the easiest things for us are to look and see what we can do to help the earth right now. And a lot of that just completely coincides perfectly with the boycotting, the low buying. Yes. Yeah, the thrifting, exactly. No big box stores, exactly, because those hurt the environment too. So for us, it makes it a lot easier. I'm at a point now where I'm like, look, let's just use what we have, everybody. Let's use what we have right now, and put that cash under the mattress. Yes, the overconsumption, exactly. No margarine. Now, come on, now we got it. We can't live that way. That's just crazy town. No margarine. That's too much. Secondhand stores, exactly. One of the things we started doing too is, in our grocery store, is that they have a bin where you can donate to the food pantry. So, we buy our groceries, but then we also buy a bag full of groceries of pantry necessities. Peanut butter and jelly, everybody. Peanut butter and jelly. That's what they want, all right? Peanut butter and jelly. So we buy extras of those and we leave it at the food pantries, or we take it to our youth shelters. So, it's not a lot, but it's what we can do. So I think that's important. Right. The small businesses get hurt. Exactly. So if you can donate PB&J, that's like going to be so amazing. But again, you just do what you can do. If all you can do right now is learn and figure out how everything's working and what's actually happening, that's amazing. Do that then. It's okay. PB&J, I know, I need to. I'm like buying PB&J like nobody's business. And I'm just like, here you go, kids. Like, I'm sorry. The world's crazy right now, but here's some PB&J. Oh my God. You can learn to can. Absolutely. We're freezers here, so I don't can, but I do freeze a lot of stuff. Get more involved. Absolutely. Yes, canning food is vital. I wish I could. I've got some OCD people in my home, and so the canning doesn't go over well, but I do try. We do try. And of course, with the schools, we try to donate as much as we can there as well, because I'm donating the highlighters, right, and the markers. I'm like, who needs markers? You too, Kristen. You too. So, homesteader, yeah, of course. So, but the point is that this is the time. This is the time to step back and to reassess and just say, what is it that really needs to happen here? I know the quick way, the fast way to do it, the easy way to do it, all right. But if it takes a little more time, but does a little less damage to the environment, or stands up and says, I'm not going to purchase from you because, you're bad, then I think that's great. Yes, I love it. So I think anything that you can do to kind of, anything each little day, it's those decisions that help. So go and learn as much as you can. but not to a point where you're like, oh my gosh, the world's on fire. Then that means you've learned too much today. You've learned too much. Back away, back away. Oh, with that, everyone, go ahead. My battery's starting to fade. So thank you all for coming and hanging out with me and my green nails today. Kind of minty, actually, under the lighting here. But I appreciate it. This case, again, is really important. This decision, I think, is incredibly important. This is the Wilcox case, in case you're wondering. I will be putting this up on my Tube of You later today, so I should have that posted so you can listen to it again for those of you that came in a little bit later. So this was a situation where the court came in and said, the statute said it's 5 years and, got to follow the law. If you don't have good cause, you can't get rid of them. That's what the law says, and that's what we're going to do. So have a great rest of your day, everyone. I will be up doing a closet docket update at some point. Not sure exactly when, but very soon. Take care, everyone, and I'll see you all again very soon.